I've been asked a lot, what does the term VRA mean? And as lawyers, we like to abbreviate things and we don't think about the fact that a lot of people are going through this system for the first time and they don't understand these acronyms. So I want to dig into VRA, what that means legally and what that means realistically if you're charged with an act of domestic violence in Colorado. The VRA stands for Victims' Rights Act. It's a Colorado constitutional amendment that says victims have rights in domestic violence cases. Just as much as defendants have rights, victims have protected rights too. Now, it's not the same type of rights, and I want to go through what those rights are. But in essence, what it means is if someone is an alleged victim in a case, they have the right to be heard, they have the right to know what's happening in the case, and they have the right to be kept informed throughout the progress of the case. There are also crucial times in the case where they are mandatorily required to be notified of what's happening by the district attorney. So a couple of those mandatory requirements that they must be notified and their input can be allowed if the victim is contacted. The mandatory dates are any kind of bond or advisement hearing, anytime a bond is going to be changed or there's going to be an argument made to try to change a bond, the victim in the DV case has the right to be heard on that issue. If they're not coming to court, they still have to be notified by the district attorney that this is going to happen because the defendant in that case cannot argue without VRA being complied with. In other words, if the DA doesn't do their job and reach out to the victim, the defendant sits there and waits until the district attorney actually reaches out to the victim and gets their input. Generally speaking, DAs are very good about reaching out because they know the judges will get on to them if they're leaving defendants sitting there and waiting. But that's a huge, huge thing that comes up where they'll say, well, we haven't complied with VRA. A lot of the times my clients will say, well, can I get this modification or can I go out of state? Can I do this thing? And I have to tell them, we have to comply with VRA. So if you want to, I can file that motion, but we have to allow the DA time to ask the victim their opinion. Now, opinion doesn't mean they get the last say. The district attorney in the state of Colorado is the entity that charges someone with a domestic violence charge. But under the VRA, the victims have the right to be heard. They don't have the right to be listened to necessarily. So for example, if someone gets charged with a harassment case, the lowest level domestic violence charge that we typically see where they were texting too much, and the victim in the case says, I want this person to go to prison. They have the right to be heard on that, but the DA is not going to listen to that because number one, that's not a legal remedy for a misdemeanor charge. And number two, it's not proportional to the crime, but they still have the right to say what they want to say before the judge. And this can be incredibly frustrating dealing with these charges where you're not only having to fight for your life and your freedom, but you're having to make sure that everyone else is abiding by the specific rules to allow the victims to speak, to allow the timing to be done properly. So it can get very convoluted and frustrating. Other things to be aware of on this VRA issue are the victims have to be notified of bond requests or any modifications. They also have to be notified of any potential plea offer that the DA is wanting to make. So even if your attorney is fantastic and does a great job and gets you exactly what you want, if the DA hasn't talked to the victim and at least let them know what the offer is going to be, we don't get to resolve the case that day. We have to wait for the victim to be notified as to what's going to happen. Now, again, the victim doesn't have to agree to what's being offered, but they have to be told and they have to be given the opportunity to speak. Other times that the victims mandatorily have to be notified of what's happening and given the opportunity to come to court or give input, or if there's a sentencing set, they have to be notified before the sentencing can happen. And if someone is asking to have a case sealed, they have to be notified before that case can actually be sealed. Now, I know that this is a lot, and I know that when you're dealing with a domestic violence charge, it's already difficult and stressful, but that's why having an attorney on your side is so important, because we know those different times that they have to be notified. We can reach out in advance and make sure the DA is doing their job so that we can do right by you and make sure that your case is handled in the most efficient way possible.